Well, hello and good morning. Welcome to Sunday Morning Coffee with Dr. Childress here. Today, I'm going to be discussing the attorneys and the zealous advocate role that they have in the family courts. Now, I'm a psychologist, not an attorney, so I'm approaching this from a discussion from a psychological perspective. In the family courts, I'm evidence. In the healthcare system, I'm a doctor. I'm the decider of diagnoses and treatment plans. But when I move over to the legal system, I no longer in my healthcare role. I'm in a legal role of being evidence, and I allow the attorneys to present the evidence. However, that has also given me the opportunity to work with um, attorneys on both sides of the issue and to be a participant in the legal system as they approach the pathology. And so this is my discussion of the zealous advocate role and some difficulties regarding that role in the family courts. So to begin with, what I'm talking to attorneys here, potentially to the parents of the who hired the attorneys, but I will figure I'm talking to the attorneys here. And I want to emphasize that the problem that we're currently having in the family courts regarding high conflict custody litigation is because of a broken mental health system. And that needs to be recognized that forensic psychologists are awful. These forensic custody evaluations that you've been getting are awful. Now, you probably know that because you've read them. The court probably knows that. But you probably think that's just normal for psychologists. Um, and it's not. And I want to emphasize that. What you have been receiving in the family courts, these 50, 100-page long forensic custody evaluations, are absolutely awful. They are substantially substandard professional practice, but you've come to accept that. And these are doctors, and they're testifying, and they all seem to be doing it, so it must be, acceptable professional practice. No, it's not. And so that's the first thing to understand. The corollary of that is that there are no competent mental health services in the family courts. Okay. And that, let me pull up again, because that's important for attorneys and the courts to understand. There are no competent mental health services in the family courts. And the reason is these forensic custody evaluators came up with this experimental new approach, left the field of healthcare, experimented on parents, and it was a complete failure. So now we don't have the forensic custody evaluators because they're awful and a complete failure. And there's no clinical psychologists because they all left to give it over to forensic psychology. So the family courts currently have no competent mental health services. There's no diagnosis. There's no child abuse diagnosis, which is extremely concerning when the only cause of the symptoms is possible child abuse by one parent or the other. And you're not getting appropriate evidence. You, as the attorney for the targeted parent, are not getting the evidence that you need from the mental health system because the mental health system is broken. And as a result of the broken mental health system, the legal system has now compensated. And the way the legal system is compensated is in the roles of the two attorneys. The targeted parent's attorney can get no support from the mental health professionals. They're not getting the mental health evidence they need. So they're in a litigator role around the custody, trying to reach an agreement about child custody, whereas the allied parent is getting incompetent mental health services and that collude with the abuse. And so they get an attorney who has a zealous advocate role of delay and obstruction and just undermining every possibility of resolving the issue. And so one side has a zealous advocate, the problematic parent, and the other side has a litigator trying to cooperate. The other compensation that has happened is that the court has been put in a position of trying to diagnose what the problem is, because the forensic custody evaluators refuse to diagnose what the problem is. So if they don't do their role as doctors, the court then needs to step in and diagnose pathology. And the court's not capable of doing that, but you don't have any alternative from the psychologist. So it's an absolute mess relative to the broken mental health system. We need to fix that. So the mental health's mindset, the mindset of a psychologist, a real psychologist, not the ones you have in the family courts, the mental health mindset is this is child abuse, and there is a duty to protect. That duty to protect is for all the mental health people and for the court and for officers of the court. And you've been lulled to sleep. All you family law attorneys have been lulled to sleep by the incompetence that you've been receiving from the forensic custody evaluators regarding child abuse and informing the court, and spousal abuse and informing the court, and returning a diagnosis and effectively treat. You've been lulled to sleep. None of you, the court doesn't recognize the child abuse. It does, but it does. It's not getting that information from the psychologist, and you aren't getting that evidence to present to the court that it's child abuse. So nobody's acting like it's child abuse or acting like it's spousal abuse. Your client is being spousally abused using the child. Your client is a spousal abuse victim. They need you to protect them from the spousal abuse. Their child is being psychologically abused and having their life destroyed by the other parent. Your client needs you to protect their child from child abuse. So that's the reorientation that needs to happen as we get a fixed mental health system that will allow the legal system to function properly. So here's a situation right now. We have two attorneys. You have the attorney for the targeted parent, and then you have the opposing attorney. And the mental health evidence is just an abomination. Okay, it's got massive holes in it. It's just awful. The mental health professionals, the forensic psychologists, are colluding with the pathological parent and the child abuse that's going on and the spousal abuse that's going on. So you, as their targeted parent's attorney, really don't have access to the mental health, whereas the opposing attorney just feeds off of the mental health people saying, oh, the child's not ready yet, we need reunification therapy and various delay tactics that will never fix anything in the family. What we need is better mental health evidence. We need to get you the type of mental health evidence that you need to protect the client's child and to protect your client from spousal abuse. That's what needs to happen. So we're going to be changing how the family courts function, because we're going to be fixing the mental health system. Now, the legal mindsets, here's from a psychologist, here's what I've noticed about your legal mindsets. And I grew up in a legal family. My dad was an attorney. My brother was an attorney. My best friend was an attorney. I grew up in a legal mindset. So first we have the zealous advocate role. A lot of times people call them a shark or a pit bull. Now, I'm with a honey badger. Honey badger don't care, A honey badger is just a ferocious thing that will intimidate any other animal. A honey badger don't care. Then the other mindset is a litigator, and litigators seek agreements. And I know where this comes from. Okay, you have the zealous advocate role. That's your obligation within the adversarial legal system. However, you also want to win the case for your client. You're concerned because court decisions are always variable, And if you can reach a settlement, an agreement, that puts you in the best position of getting your client what you want without putting a lot at risk and various things. So attorneys tend to prefer settlements and agreements rather than trials and litigation kind of things. So we have the zealous advocate role, but then the more cooperative litigator agreement kind of attitude or mindset. The other feature about attorneys is your mindset about winning and losing. So you get paid either way. However, it feels a whole lot better when you win the case for your client. And when you lose the case for your client, you feel bad for them. And they're often upset or angry with you. And then you wonder, could I done more? Did I do the right thing? You like to win. Okay. So I understand that. And with the case that you have, the mental health people and various aspects of the situation, a narcissistic parent, you're not optimistic that you're going to be able to win this case. And so you try to settle it out. You try to get agreements that can get some closer to the situation because you want to win for your client or get them the best possible. That needs to change. Okay, we need to switch over to the zealous advocate role and get you a winning case, get you the evidence that you need for that. The other feature about your legal mindsets is family law is unglamorous. Now, this is, again, from the outside, but I've heard reports. It's unglamorous for the psychologists, too. Nobody wants to work in the family courts. People look at me with like terrified expressions, other psychologists, when they learn I work in the family courts. But, other attorneys, you're not the high-powered attorney stuff. You're working family conflict that never gets resolved, and it's just a difficult field. And we'll talk about changing that and updating that. And then you have a broken mental health system that's forced you to compensate. So the issues in the two systems is the legal issue is the custody decision by the court. And let me emphasize that because you're an attorney, that's your mindset. That's where you're thinking. The issue is the custody decision by the court. However, that's actually not your full role because the mental health issue is treatment by the doctors and you are working for your client. And so it's your obligation as the attorney to get the court orders for effective treatment of your client. Let me emphasize this. The pathological parent drives the pathology. It's a pathology, not a crime. He drives the pathology into the wrong system for solution, into the legal system where everybody fights and where it can manipulate the legal system, the delays, the court, manipulate the legal system. It can't manipulate the doctors if they diagnose and treat pathology and they're going to treat it and fix it. And the pathological parent doesn't want it. They don't want it in the healthcare system. They want to manipulate it over here. So they drive it into the wrong system for a solution. And then you, as an attorney, buy into that. And the forensic psychologist bought into that it's a custody decision. It's not. We need to treat and fix the pathology in the family, the child abuse, the spousal abuse. This is a treatment issue. And so our landing point is not on custody, it's on treatment. And so reorienting to that would be vital. So the legal issue, the custody is a false issue. It's manipulation by the pathological parent, and we need to land on treatment. The targeted parent in the current situation has a litigator who's seeking to get the best possible because you don't have really the evidence that you need. The allied parent has a zealous advocate because they have the awful mental health evidence and they are working on the principle of delay, delay, delay. When we reorient, however, to understanding that this is child abuse we're talking about. You've been lulled to sleep by the forensic people. Stop it. Wake up. Once we realize this is child abuse, then the targeted parent has a zealous advocate And the allied parent has a litigator because we've gotten you the better evidence. And so once we get that child abuse diagnosis back from your mental health professionals, and that's our goal, and the spousal abuse diagnosis, then you have the evidence to go into the court as a zealous advocate asking for a child protection response rather than a custody decision. That's the change. When we fix the mental health system for you, we're going to get you better evidence that you need to win your case. Meanwhile, the opposing counsel will not have the mental health evidence, so they'll switch over to being the litigator seeking agreements because they know if you go down this path, their client is going to get a protective separation from the child and they label the child abuser because that's what it is, child abuse. And so once we get this fixed and on the proper path, then the roles will switch. You become the zealous advocate for the targeted parent to protect your client from spousal abuse and to protect your client's child from child abuse. They love that child. The child's life is being destroyed. You need to protect that child for your client. And so you'll switch to the zealous advocate role, and the opposing party will switch to the litigator role because they'll want to settle out because they realize what's happening. Then we can talk about the contingent visitation schedule as part of that settlement agreement. But so with child abuse and spousal abuse, the zealous advocate role is your responsibility to protect your client from spousal abuse, to protect your client's child from child abuse. So we need to get you better mental health evidence so that you can do that. So you need better evidence from professional psychology. So let's get you better evidence. That's what we need to do. First off, to get you better evidence, what we're going to need to do is you need to hold incompetence accountable. Be the honey badger for your client. Okay, we need to clean up the mental health system. And it's up to me, I'll help and get you the proper evidence from professional psychology. That's my role as a second opinion. But you must hold incompetence accountable. And here's why. All the attorneys, the family law attorneys before you, have not done that. And look what's happened. All the targeted parents for years get incompetent mental health services. You need to fight for your client to get competent mental health services. And if you terrify the incompetent mental health professionals and go after their license on the stand and really go after them as a zealous advocate for their incompetence, they will up their game substantially and they will become competent. That's how we do it. However, if you try to have the litigant mindset and work on agreements and manipulate the court and work with the broken mental health system with this lousy evidence, you're not going to go after the incompetence and you're going to leave them there for the next family and the next family and the next family. So you need to terrify incompetent psychologists and you need to go after their licenses for ethical violations. Now, your client may not win this decision, and you can talk to your client about that. I can talk to them, and I think they'll be happy with that temporary outcome. Your client may not win this decision, but Honey Badger don't care, because without a child abuse diagnosis, your client will lose their life and lose their child. And so that's important to understand. If when we land on treatment instead of the custody decision, we do not have that child abuse diagnosis, we will be treating cancer with insulin. And the patient will die from the misdiagnosed and mistreated cancer. We need the child abuse diagnosis. This is from the psychologist, okay, the clinical psychologist. For treatment to be effective, we must protect the child. That means we need the child abuse diagnosis to justify the child protection response. In addition, we need to protect your client from spousal abuse using the child as a weapon. This is a brutal and savage spousal abuse of your client. We need to protect them. We have two duty to protect obligations, and we need you to be a zealous advocate role, protecting and advocating for the protection of your client. Okay, so we need that child abuse diagnosis. So, as a family law attorney, it is incumbent upon you to understand the pathology that's involved. This is brutal spousal abuse of your client using the child as a spousal abuse weapon. This is child psychological abuse, DSM-5 diagnosis. We need to protect the child, so we need to the child abuse diagnosis, and it's your obligation to get that. Now, I realize you're an attorney, you don't make the diagnosis, but we are going to need the court orders to get the mental health system to make that diagnosis, and we can do that. We need to kind of up the quality of mental health services, and we do that through second opinion. So there's barriers, but we just overcome the barriers, and we need you to navigate the legal system in overcoming those barriers for your client. So the other feature about this is family law will become a substantial subspecialty, because the family law attorneys are going, from here on out, are going to need to learn some psychology, because you're going to be working with the mental health system that knows the psychology and that actually exists. So you're going to have to know stuff like persecutory thought disorders. Not a whole lot, but just basically what they are. This is a persecutory thought disorder, persecutory delusion from unresolved trauma. It's not a psychotic range one like schizophrenia. It's out of unresolved trauma. You'll need to know factitious disorders imposed on another, and that's the attachment system. So you're going to have to know authentic and inauthentic attachment. Dark personalities, definitely. Dark triad, vulnerable dark triad, and dark tetrad. Let me just say about that with your client. The ex-spouse of your client is a dark personality, dark triad, narcissistic, psychopathic, and Machiavellian manipulation. Or the borderline spectrum, if your client's a dad, the ex-spouse is a vulnerable dark triad, vulnerable narcissism, psychopathic, manipulative, and borderline pathology. Add sadism, and you get the dark tetrad. That's particularly of concern if your client is a woman and the pathological parent is the narcissistic dark triad dad. You add sadism to that. That's a very dangerous pathology. It's been called the core of evil in the research literature, the dark triad, dark tetrad. And so that's a dangerous human, and they're abusing your client. We need to get a handle on this and protect your client and protect your client's child, because your client loves that child. That's their life. So we need to do what we need to do to protect the child. And then, so dark triad, but then you're also going to need to know family systems, just basic stuff, cross-generational coalition, inverted hierarchy, emotional cutoff, triangulation, just basic stuff. Now, for opposing counsel and the zealous advocate role, I will note that attorneys are officers of the court. Attorneys should not use their craft to assist their client in abusing the child. Attorneys should not use their craft to deceive the court into participating in the child abuse by their client. All officers of the court need to have the goal of getting the court accurate information on which to rely for its decision-making surrounding the child. So in all cases of custody conflict involving severe attachment pathology, when we're worried about child abuse by one parent or the other, We need to get a proper risk assessment for the differential diagnoses involved. So stop delaying that. Stop trying to not get that. All attorneys need to be working towards that goal. Boom, the moment we see the pathology, both attorneys say, okay, let's get a diagnostic risk assessment. The court says, okay, let's do that. And we move it quickly into getting a diagnosis for the court. Is it authentic child abuse by the targeted parent, or is it a false attachment pathology and child psychological abuse by the allied parent? Which way are we going to go on that? We need an answer for that for the court. And so that once we start doing that, everybody gets on board and we can figure this out and solve the problem for the courts, solve the problem for the children, solve the problem for the parents. So important to understand. Important. This is spousal abuse of your client using the child as a spousal abuse weapon. This is child abuse of your client's child. The child needs protection and treatment for child abuse. And you need to make this happen for your client. Okay. Now, I'm here to help. I'm the psychology side. I'm the mental health wrangler. I can help you get the mental health services that your client needs. But I need you to be a zealous advocate and to go into the court with the goal of protecting your client, the parent, and protecting the child from child abuse. And child abuse always takes precedence over other dangerous pathologies. So here's to understand about your current forensic custody evaluations. New York Blue Ribbon Commission, by an independent review of forensic custody evaluations, found that by an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased, harmful to children, and lack scientific or legal value. At worst, evaluations can be dangerous, particularly in situations of domestic violence and child abuse. Do not get a custody evaluation. 6 to 9 months, no diagnosis, $20,000 to $40,000. No. This is also financial abuse of your client using the legal system as the spousal abuse weapon. And so we need to limit the financial costs to your client. So let's get a diagnostic risk assessment. We can pull that in for $25,000, maybe $5,000, somewhere in that range. We can get that. We can get a second opinion from telehealth on it, a third opinion from telehealth on it. It should be returned in about 4 to 6 weeks. So we can get a quick, focused, which parent is abusing the child? Authentic child abuse or persecutory thought disorder? Let's look at that focused issue. Custody of the court's decisions. Let's get a diagnosis so that the court can make an accurate and good decision surrounding the child. And so let's everybody just work to get a proper assessment, and so we can do what's needed to protect the child. So here's the solution out of clinical psychology. Forensic psychology needs to go away. Their custody evaluations need to go away. Clinical psychology needs to return, and here's a solution. Clinical psychology: diagnosis guides treatment. Treatment for cancer is different than the treatment for diabetes. Which parent is abusing the child? That's going to result in drastically different treatments. And the appellate system in healthcare for disputed diagnosis is second opinion. This is in the legal system. It's going to be a disputed diagnosis. So rather than getting an assessment and a diagnosis, then disputing it, then getting a second opinion, a second diagnosis, and then getting dueling arguments between what healthcare would do is it gets the second opinion right up front. Doctor, this hurts. Let's get a second opinion and get an accurate diagnosis. So let's get the second opinion right up front. We can do that with telehealth, which is exactly what telehealth is designed to do. I'm on a secure platform. Doxy me. It's HIPAA secure because that's what telehealth is designed to do, is second opinion consults. And so let's do that. We can get a third opinion. So what the court order is going to ask for is a clinical diagnostic assessment to the differential diagnoses of concern, and that each party be allowed to appoint a second opinion on that clinical diagnostic assessment in telehealth. That will then feed into the court's decision making surrounding the child and ultimately into the treatment plan for that. Now, there's on the New York Blue Ribbon Commission report, there's an analysis of it, a discussion of it by two of the commissioners. It's up on YouTube and you can Google it. I recommend all family law attorneys Google that discussion of the New York Blue Ribbon Commission by the two of the commissioners. They're both attorneys. And they took a very legal perspective on their discussion. I take a very psychological perspective, and boy, they're bad. They take a legal perspective and say, boy, they're bad. And one of the arguments they make is this forensic psychologist has essentially become a fact finder for the court without any of the legal protections about relevance or, the evidence that they're fact finding about, biases and all sorts of problems. And so, but we can't insert attorneys to protect the legal rights of litigants in a clinical assessment. The solution is to appoint a doctor representative to participate in the custody. That way, each litigant has a representative on the assessment to make sure that their concerns are adequately and properly addressed. That's the way you solve it. You let each litigant appoint their consultant, then you get all the doctors together, and it's up to the doctors to then return an accurate diagnosis. We can do things like rule out, we can do things like response to intervention. There's things we can do, but it's up to us to get the court accurate information around child abuse and spousal abuse. Is a persecutory delusion, isn't authentic child abuse, what's causing the child to reject a parent. Now, so that's kind of your visual model of the court order. However, this is actually what the overall situation needs, because we're not ending on the diagnostic assessment. Notice that's in the middle. We're ending on treatment. We need to fix the problem. We need to protect the child from child abuse. We need to get this child a normal range and healthy life, and we need to restore loving attachment bonds to everybody in the family. So we need effective treatment. That's where we land. And notice how getting those second opinion consultants then benefits the treatment, because they have now been involved in the diagnostic assessment and can continue their consultation into the treatment phase as well. And so that substantially improves the quality of healthcare services delivered in the family court. And so that is the clinical psychology solution that we need to get, and that you need to navigate through the legal system, and then we need to get the mental health system to jump up and support that. Now, currently, I said there's no competent mental health services in the family courts. Your choice in finding those, and it's up to the targeted parent mostly, is you can recruit out of clinical psychology to come back to the family courts, but they won't want to do that, and they're not competent in family court pathology and attachment and all the various things involved. Dialectic behavior therapy knows borderlines, spousal abuse therapists know the narcissistic dad pattern, but they're not working in the family courts. That's the problem with 40 years of a failed experiment. We will get that within a couple of years. Boom, we'll get the expertise, but it doesn't exist now. The other alternative, and one I probably would recommend, is you look for early career forensic custody evaluators, forensic psychologists who are willing to switch or interested in switching from a forensic custody evaluation to a clinical diagnostic assessment. And so you make them the primary, and then you add a second opinion consultant from each party on them, and then that develops a court. And then look what happens. You have somebody in your region, somebody in your location who has done this with second opinion. Now you can do it the second time, and they can consult with somebody else, and we can start. That's all called building capacity. So we need to build capacity. So we'll get custody evaluator or forensic psychologist to switch over clinical diagnostic interview, get some support for their initial couple of assessments, and then boom, we have competent mental health services in the family courts. So with that, that's my talk on the zealous advocate role in the family courts. Targeted parents need zealous advocates, and they want zealous advocates. And they will understand if they may not win this particular round of things, if they believe you are sincerely and zealously fighting for the protection of their child and for their protection. And so we can do this through a couple of rounds. It's not an Olympic sport. We don't need to, nail the landing here. We can successive approximations. We can get closer and closer to what we need through your court order, but it is child abuse, so we need to get on it quickly, and we need to be focused on what our goal is, which is child protection, which means getting that accurate diagnosis. So with that, take care, everybody, and I'll check in next week with some other aspect of family court pathology. Bye-bye.